Hello and happy Monday. My name is Michael Leeserman here with the Trial Guide's tip of the day. The date is April 7th, 2025, and our tip today comes from the Deposition Handbook. The purposes of discovery are to squeeze the witness dry of all relevant information and to bind the witness to a particular version of the facts. To achieve these discovery purposes, you must continually invite the deponent to talk. For example, you may ask, are there other facts upon which you base your claim or defense that such and such? Until the answer is no. Yeah, lots here, and it's different for fact witnesses versus expert witnesses. And for expert witnesses, we may be in federal court, and under Rule 26, the expert is bound by the report. And so for that instance, we might say, all right, you gave this opinion number one. What is your basis for that? Were there other bases? Anything more, and exhaust that. When it's a fact witness, we want to do the same thing. We don't want to be surprised at trial. And I'll actually say that. I'll say, I'm asking these questions because I want to know when you come to trial, are you going to testify about this? Is there anything else you know? Is there anything else that you base your opinions on, or anything else that you saw or perceived at the scene, whatever your case is? So I know there's different philosophies on taking depositions. Some people think just ask close-ended questions and lock the deponent down. There's certainly a time for that. And certainly if you think you may be facing a motion for summary judgment, you want to get those little transcript chunks or sound bites so that you can oppose summary judgment, or you may have a proactive summary judgment you want to file. Get those transcript chunks, I like to call them. And there's also part of the deposition where it is true discovery. You want to know, what does this person know? You want to make sure you've exhausted everything though. Is there anything else? You've exhausted everything that they know. Is there anything else you know? Is there anything else? What else do you base your opinions on? What else did you see? What else did you perceive? Was there anything else that you heard or felt at the scene or at the hospital or in the nursing home, whatever type of case you have? But you want to exhaust the factual bases for which the client or the deponent has an opinion, right? Or the defendant, or whoever the deponent is. You want to really try to make sure there's nothing else. And by doing that, it can be a little tedious, and it's better than being surprised at trial. Is there anything else? Is there anything else? And again, this is especially helpful with experts. Anything else on which you base opinion number one? Let me know what it is. Let's take a deep breath together now and be grateful to be alive this Monday. May the work we do today help remind us that as much as ever, it's important that we turn to law in our society as a unifying and guiding force. May the work that we do today help to reduce suffering in the world. May it repair the world. May we fiercely and compassionately advocate for our clients. I'm going to ring a bell 3 times now. This can take you into a meditation practice, a prayer practice, or just remind you, it's Monday. Wake up, go out, do good things, and have fun while you're doing it.